All right, so let's get started with our brief conversation about attempt crimes. Broadly speaking, attempt crimes fall within the category of inchoate offenses, and you should have taken a look at the link to the video on Twin that gave you a synopsis or an overview of inchoate offenses. You are responsible for all of the information in that video. So, to the extent that there's conversation about attempt, and conspiracy and other inchoate offenses. You're responsible for that information. In this recording, we're going to talk in particular about attempt crimes. So, first, the overview. Attempt is a crime in and of itself, separate from a completed crime to which it relates. An attempted crime is one in which a defendant tries to commit a crime but is unsuccessful for one of two reasons. Either the actor does everything planned, but the actor's conduct does not reach its intended result because of some other factor. Maybe law enforcement intervenes, maybe the individual just screws up or messes up, but in any event, these are what we call completed attempts. If you take a look on Twin, you will see a link to a video of a completed attempt. This is the attempted assassination on Ronald Reagan. So in that case, you will see Hinckley having completed his attempt crime. The other form of an attempt crime is when the actor does some of the acts, but does not finish, does not complete the steps, either because he ceases to do so on his own or is prevented from completion by an external factor, such as law enforcement. So in these cases, there is still something left to be done by the actor, and we call these incomplete attempts. Also on Twin, there is a link to a video of an incomplete attempt of an ATM theft. So take a look at both of those videos just so you get a sense of what a complete attempt or an incomplete attempt might look like. So we criminalize attempts for a number of reasons, including to be able to guide law enforcement as to when to intervene to prevent the commission of a crime, to protect people from those who are predisposed to commit a crime and might try on repeated occasions to complete a crime, and then because we do not want to allow an actor to avoid merely liability merely because he was lucky and the result didn't occur. Notice one of the reasons we criminalize attempt is not deterrence. We're not necessarily seeking to deter individuals, but we're trying to guide law enforcement authority. We're trying to protect people from those who would try and repeat crimes, and we're endeavoring not to allow people to avoid liability just because they're lucky and didn't complete their goal. With respect to attempt crimes, it's important to know that jurisdictions have enacted very basic attempt statutes that require a high degree of judicial interpretation. So legislatures vest a great deal of discretion in the courts, which harkens back to the days of early common law crimes. That being said, when we're dealing with attempt crimes, we are not concerned about violations of the legality principle. Another important point to know is that attempt is a lesser included offense of the completed substantive offense. So, for example, attempted homicide is a lesser included offense of homicide. A defendant who is charged with both the completed substantive offense and the attempt to commit the substantive offense may not be convicted of both charges. The individual can be convicted only of one offense. That being said, a defendant who is charged only with attempt may be convicted of attempt if the state proves the completed offense. So, going back to my example, if an individual is charged with attempted homicide as well as homicide, he may not be convicted of both offenses. On the other hand, if the defendant is charged only with attempted homicide, but the government is able to prove the actual homicide, then the defendant may be convicted of the attempt, even though the homicide was not charged. Last introductory point is punishment. Under common law, both traditionally and in modern times, attempts are punished less severely than the completed substantive offense that was intended. It is important to note, however, that under traditional common law, the disparity in sentence was greater than it is today. All right, so attempts are punished less severely than if the individual had actually completed the substantive offense and reached the ultimate conclusion. On the other hand, the Model Penal Code has done away with a punishment differential between attempt and completed crimes, except in the case of capital and first-degree felony cases. So for capital or first-degree felony cases, attempt is punished as a felony of the second degree. For all other cases, the punishment for attempt is the same as for the substantive offense. So another way to think about this is that for the most serious crimes, attempt is punished less severely, but for all other crimes, those less severe crimes, the attempt is punished the same as for the intended substantive offense. And the reasoning of the Model Penal Code drafters is that the actor's state of mind is the same regardless of whether or not he commits the substantive offense or only the attempted offense. And so the culpability, the dangerousness, and the need for punishment are the same, although some grace is granted for those most serious offenses. All right, so when we're looking at attempt crimes, as we do with all of the other crimes that we've studied both in the abstract and more particularly, we have to consider both the mens rea requirement and the actus reus requirement. And we're going to take a look first at the mens rea requirement as set forth in the Gentry case. So take a look at the first slide. Here in the Gentry case, we're trying to ascertain what does an individual's mindset have to be, or what does the individual have to be thinking about when committing an attempt? What is the culpability, or what is the mens rea? So in Gentry, we have the defendant charged with attempted murder, and the testimony at trial established the following: that the defendant and his girlfriend lived together, they were cohabiting, and one day they spent a fair amount of time at home drinking and ultimately became intoxicated. At some point in the evening, they began to argue, and the defendant apparently spills gas on the girlfriend, and the gasoline ignited when she went near the stove. Defendant tried to smother out the flames, but his girlfriend still was severely burned. So these facts that were presented at trial seem a little far-fetched, and so if you try and paint a picture or a story as to what might really be going on here, we might infer or conclude that this was an abusive relationship, and that the victim, the girlfriend, originally told the police that her boyfriend had tried to kill her and that she had feared him, but that she unexpectedly changed her testimony at trial, maybe because the two had reconciled, or maybe because she had been intimidated, or just general reluctance to be involved and to be a witness. And so in light of what we understand about intimate partner violence, this is not an unsurprising turn of events. All right, it is often the case that a victim, a complainant, will provide one version of events to law enforcement when they're being interviewed, or will testify before a grand jury as to one version of events that incriminates an individual. But by the time of trial, the victim, the complainant, has changed her story, sometimes and oftentimes unexpectedly. So we might imagine that that's what happened here, and how we get into this position of the government being a little bit surprised at what it's hearing. So the trial court instructs the jury on attempt. And in particular, it instructs that a person commits the offense of attempted murder when he, with intent to commit the offense of murder, does any act which constitutes a substantial step toward the commission of the offense of murder. The offense attempted need not have been completed. With respect to the mental states, the trial court instructs that the government had to prove any one of four alternatives, any one of four mental states: intention to kill, intention to do great bodily harm, knowledge that the acts will cause death, or knowledge of a strong probability of death or great bodily harm. In light of the facts and in light of the instruction, the defendant is convicted and appeals. And on appeal, the defendant challenges the trial court's jury instruction on attempt. The Defendant argues that attempted murder requires proof of the specific intent to kill, and that providing the jury with alternatives to finding the mens rea or the specific intent to kill would allow conviction based on a lesser intent than required by law, right? So the defendant argues on appeal that the government should have been required to prove the specific intent to kill. But if you look back at the trial court's jury instructions, that was one of the permissible mens rea that could be established, but it also provided three other alternatives, and the defendant argued that that was erroneous. The appellate court rules in the defendant's favor and holds that, in light of precedent, a specific intent to kill must be proven. Merely proving intent to do bodily harm or knowledge of the potential consequences is insufficient. So what's the rationale? The murder statute permits liability based on intention, knowledge, recklessness, or negligence. But the attempt statute requires the specific intention to commit the substantive offense. Thus, permitting proof of some alternative mental state beyond the specific intention to kill would be contrary to legislative design. All right, so now that we understand the rule that comes out of Gentry, one question that you should be able to consider is how many intents or mens rea must be proven? And if more than one, what are they? I'm going to suggest here, and as indicated in the PowerPoint slide, there are two mens rea that must be proven. The intention to commit the act constituting the attempt. So here that would be pouring gas on the victim and setting her on fire. And then a second mens rea is the specific intention to commit the substantive crime. Here, kill the victim. Now, many times, in light of the facts of a case, proof of those two intents merge or are interrelated. And so the primary issue is just whether or not the defendant had the intention to commit the completed offense. But sometimes those might be distinct. And we'll see that in a number of problems that we'll work through. Ultimately here, on these facts, the court reverses and orders a new trial. And so what we're going to do is consider what might happen on retrial in several different scenarios. So take a look at the next slide, which presents essentially the same facts about the gasoline being on the victim, the victim being lit on fire and suffering severe injuries. All right, but we've got some different scenarios. So first, assume that Ms. Hill's testimony that she was accidentally set on fire is incredible. In other words, unbelievable. And assume that the government offers credible evidence that the defendant threw gasoline on Hill and then threw a lit match at her, causing her to catch on fire and suffer serious burns, even though the defendant tried to smother the flames. In this case, can the government prove the requisite mens rea, right? Can the government prove both mens rea required for the intent? So there is evidence that he intentionally performed the acts that constituted the attempt, right? So he threw gasoline on Hill and then he threw a lit match at her. But is there direct evidence of his mens rea with respect to the homicide, with respect to the death? Did he have the specific intention to kill her? There is no direct evidence. We have no confession or no statement from the defendant explaining that this was his specific intention. But the government might argue that circumstantially, there is evidence of this specific intention to kill. Remember way back when we talked about, I believe it was mens rea in the beginning of the semester, right? We talked about the natural and probable consequences doctrine. So we might invoke that here, right? Based on the facts, we could conclude that the defendant had the specific intention to kill, that the natural and probable consequences of his actions of throwing gasoline on Hill and then throwing a lit match at her are to kill her, right? And we can further buttress that argument by considering the fact that earlier in the evening they had been arguing, right? So he might have had some animosity or some reason to be mad at her, And that would further demonstrate that he had the specific intent to kill her when he threw gasoline on her and threw a lit match at her. Now, the defendant's going to respond, right? Maybe there was some intention short of killing her. So maybe you could still use intend the natural and probable consequences, but the question would be, what would be the natural and probable consequences? Maybe the defense would argue that it was to seriously injure her, which is insufficient. And what would the defense point to? Well, we don't know how much gasoline he threw on her. We don't know where he threw the match in relation to her physically or on her body. We don't know whether he attempted to put it out or whether he delayed smothering the flames. So we might have some, right, questions still about whether or not he had the specific intention to kill her, and the jury might be able to have some debate, but would have to come to some resolution. All right, now consider another scenario, the second one, which is we have the same facts where the victim claims that she was accidentally lit on fire. All right, but now assume that we have evidence that the defendant threw the lit match after throwing gas on her, but only to teach her a lesson or punish her. So now we have some more information about the defendant's mindset. Assume he, even that he said this to the law enforcement. So maybe we have a stronger case for the defendant, right? Now we have direct evidence that his specific intention was not to kill her, but to just teach her a lesson or punish her, which by implication suggests that he didn't want her to die. He wanted her to continue to live so that she would understand the wrongs that she had committed. All right, so a third scenario is assume, again, the same facts. She testifies that she was accidentally lit on fire, but that is unbelievable, right? There's evidence the defendant threw gasoline on her and then threw a lit match. But we have now additional evidence that the defendant threw the lit match knowing that doing so might result in her death. Does that strengthen the government's case? It's helpful, but notice knowledge is not equal to intention, right? Acting knowingly is not the same as acting intentionally. So the fact that he might know is not enough necessarily to create specific intent to kill. All right, so we still might have some work to do if we are the government. All right, so the takeaway, right, is that there must be a specific intention to commit the acts that constitute the attempt, as well as a specific intention required for the completed crime. And so depending on how the facts come out, we may have some difficulty proving that directly or circumstantially. Next slide. The Model Penal Code takes a quite similar but somewhat distinctive approach to analyzing attempt crimes and the mens rea. If you take a look at page 774, note 4, you'll find the analytical framework, right? This is a completed result offense, and so you would look at 5.01, subsection 1B, which requires proof of culpability for the murder. And here under the Model Penal Code, that would be acting purposely or knowingly or recklessly under circumstances manifesting extreme indifference to the value of human life. As well, the government would have to prove that the defendant acted purposely to kill or with the belief that the conduct would cause death. All right, so the Model Penal Code, like the common law, does impose two mens rea requirements. The specific mens rea required for the completed crime, here murder, as well that the individual acted purposely to kill or with the belief that the result, the death, would occur. So if you take a look at the notes beginning on page 774 and carrying over to 775 on your own, consider how these cases would turn out under a Model Penal Code analysis, right? Consider how the various fact patterns proposed would be resolved under the model penal code analysis. I'm going to suggest to you the answers, and then we can work through them online if you have some questions or thoughts. So with respect to A, that the defendant did it with the purpose to kill the victim, he would be guilty. With the evidence that the defendant did it to scare the victim but believed it would result in her death, then he would be guilty. If he did it to scare her but knew it might result in her death, then he would be not guilty. And then finally, if he did it as a prank or a practical joke, right, he failed to realize the danger to the victim, he would be not guilty. So again, work your way through these various fact patterns in the notes under the Model Penal Code, and let's talk about it online. Okay, so after demonstrating the mens rea, right, we also have the actus reus requirement. And so take a look at the next slide. The question becomes, what is the standard, or how do we determine whether or not the defendant has committed enough acts to constitute an attempt? All right. One thing we do know that is mere thought is insufficient to warrant criminal liability. So merely just thinking about a crime and planning a crime does not constitute an attempt. If you then begin to engage in preparation, mere preparation also is insufficient to warrant criminal liability. But then on a spectrum, the question becomes, well, how many or what types of acts are required such that we have moved beyond preparation and into perpetration? Asked another way, how close do we have to be to completion to find an attempt? So we have Mandujano, which presents the large sort of macro view, and then we have a number of different tests set out in the remainder of the cases that help us unpack this actus reus requirement. So Mandujano involves a federal attempt statute, 21 U.S.C. section 846, and the statute, as I suggested in the introductory comments, is fairly broadly written, and it does not define attempt. There's also no legislative history that would help ascertain the meaning of attempt. Ultimately, the court concludes that more than mere preparation is required to constitute an attempt, but that there is no bright line or categorical standard we can apply to distinguish between preparation and attempt, or what we would call perpetration. Rather, whether a defendant has attempted to commit an offense depends on the factual circumstances. And so footnote 5 of the case and the notes after the Mandujano case, and then the subsequent cases we're going to look at briefly, provide you with the variety of alternative tests. It's important to know that these are the frequently utilized common law tests, and as well we'll see some discussion of the Model Penal Code to test. In the common law jurisdictions, there is no particular test that is dispositive, right? Jurisdictions do not necessarily settle on one particular test. Jurisdictions may use any of a number of tests, and a court may use any number of tests to determine whether or not the defendant has satisfied the actus reus requirement. So in this slide, we see the Peasley and the Reus cases. All right, those are the first two cases we look at that present tests, in particular the dangerous proximity test. In Peasley, the defendant's charged with attempting to burn down a building, attempted arson, right? The defendant had set up everything to a burn, including the accelerant. And the fire was going to be ignited by a candle that had been set up and was ready, but the candle needed to be lit in order to create the fire. The defendant hired or solicited someone to do it, but that person refused ultimately. The defendant then drives near the building, but he has second thoughts and he decides not to do it. So the issue is whether or not the defendant's acts were near enough to the accomplishment of the substantive offense to be punishable. Has he committed enough steps to have moved beyond mere preparation into perpetration sufficient for actus reus? So here there are still at least one step. There is still at least one step that needs to be performed in order for the substantive crime to occur. But the actor, the defendant, had a change of mind, and the person he solicited changed his mind. So this is an incomplete attempt. So the court sets out two rules. The first is that an overt act, even coupled with the intent to commit a crime, cannot be an attempt if further acts are needed. This is simply preparation. So even if you do one act of perpetration, right, and even if you have the mens rea to commit the crime, there is no actus reus for the attempt if other acts are needed to be done. The other rule the court sets out is the dangerous proximity test, that what we are trying to measure or balance here is the gravity of the offense and the probability of the offense. So the greater the gravity of the offense or the seriousness of the offense, and the greater the probability of the offense being committed, and the nearer the act to the completed crime, then the stronger case for calling the act an attempt. All right, so dangerous proximity, the name suggests it all. What's the level of danger? What's the probability of the act being committed, and how close physically is the act to being completed, right? So the greater those elements, the stronger the case for suggesting we move beyond preparation into perpetration. So in this case, right, the defendant had collected all of the items in the room for the purpose of setting fire to them, right? But this was mere collection in preparation, but he did not have any present intent to set the fire, and there was no physical proximity with respect to setting the fire, right? Remember, everything was set up in this room and ready to go, except that the candle needed to be lit, and yet there was no one nearby to light the candle, right? The person he solicited wouldn't do it, and the defendant declined to do it. So here, right, the gravity might have been serious, but the probability of the offense and the proximity to completing the offense were pretty low. So no actus reus. There is one rub here. The indictment failed to allege solicitation. If that had been alleged and proven, that arguably could have been a last act sufficient. So in other words, if the government had argued and proven the solicitation, right, then that might have been sufficient. But that was not the case here, so the defendant is not guilty. All right, Reus presents another instance of application of the dangerous proximity test here. A group of guys is planning to rob a man of the payroll funds. Two of the men in the group had guns, but the defendant did not have a gun. The defendant's job was to point out this man with the payroll, and the others would rob him. And so this group drives around together in a car looking for the man. They stop at several places, but they never see the intended victim. The police, though, happen to be following them, and they apprehend the group of men. So they foiled the crime. The issue is whether the steps that the defendant had taken up to the time of arrest amounted to commission of an attempt. And the court applies the dangerous proximity test, and the court states that the act amounts to an attempt when it is so near to the result that the danger of success is very great. Here, the group had gotten together. Some of the men had guns. They were driving around looking for the victim, but no actual attempt to rob the victim. None of the acts of attempting to rob the victim could actually occur until they actually found the victim. And in this case, they never found the victim. They never saw the victim. They were never near the victim. And so, right, the gravity could be strong, but the probability of the offense and the physical distance were low. Thus, the defendant is not guilty. Next slide. So in this slide, we look at two final tests under the common law, the res ipsa, or the unequivocality test, as set forth in the Miller case, and then physical proximity test, which we've alluded to in the conversation about the last two cases, but we can see more clearly in the Hinckley case. So in the Miller case, we have defendant threatening to kill Albert Jeans, right? He goes out to the ranch where Jeans is working. He goes to the field where Jeans is working, and he begins to walk toward Jeans with a 22 caliber rifle. Uh, at the time at which the defendant is about 280 to 330 yards away from Jeans, but then he's continuing to approach. And then at about 180 or 200 yards away from Jeans, he has to stop to load his rifle. He, by this point, still hadn't pointed his rifle at Jeans. He was just walking towards him, stopping to load it. Jeans sees the defendant and he runs away. It's unclear if the victim, Jeans, runs away before or after the defendant has loaded the gun. The defendant keeps on walking, apparently with the intention to carry out his crime, and eventually the constable is in his path, and he stops and he surrenders his gun to the constable. He is charged with attempted murder. And the court applies the rule that so long as a defendant's behavior is equivocal about committing the crime, he has not committed an attempt. And so long as a defendant's criminal intent is equivocal, he has not crossed the line from preparation into perpetration. So in this case, we couldn't say whether the defendant would carry out the threat to kill the gun. And so he's not guilty, right? There are lots of series of steps which still could evidence or allow for equivocation, that is, that he's not going to commit the crime, right? He had to go find the victim. He had to walk to the field where the victim was working. He had to walk a long distance. Then he had to stop to load his rifle, right? But so this is all possible equivocal behavior. He could still be equivocating or waffling or unsure about whether or not he's going to commit the crime. This is not res ipsa. The thing speaks for itself, right? And so he has not crossed the line from preparation into perpetration. And so we couldn't say whether he would carry out his threat to kill. And so he's not guilty. So, by the way, I haven't said it in a while, but it's kind of fun to say. We use the term here, res ipsa, to describe this test, which hopefully you recall from torts. Res ipsa, the thing speaks for itself. So this is like torts, but sort of not like torts. Okay. And the last test you should be aware of is the physical proximity test, which is in some ways captured by the dangerous proximity test, but is a test that stands alone in and of itself. And so in the physical proximity test, what we're trying to measure is the physical distance between the defendant and his or her actions and the unachieved goal. So how close physically is the defendant to actually completing the crime? And the Hinckley case, in which Hinckley shot President Ronald Reagan, is an instance in which we can view the application of the physical proximity test, right? In this particular case, right, Hinckley was quite physically close to achieving his goal of killing the president. He's on the scene, he fires the weapon, he's close enough to actually hit the president with his gunfire, right? So in that circumstance, we would say that under the physical proximity test, Hinckley is guilty of an attempt. He has moved from preparation into perpetration on the basis of his physical proximity to the completed crime. All right, in the next slide, we look at the Actus Reus requirement under the Model Penal Code, and we do so in the Reus case. All right, so in this case, we have two 12-year-old girls who are intending to kill their teacher by poisoning her. One brings a rat poison to school, and they are giggling over her coffee cup in the classroom when the teacher walks in on them. Another student had notified the principal of the girls' plan, and the rat poison is ultimately found in one of the girls' purses near the teacher's coffee cup, but there is no rat poison in the cup. And so in the Reus case, we're looking first at a common law version of attempt in the jurisdiction. And then in 1989, the jurisdiction had revised its statutory approach to attempts by adopting a modified Model Penal Code approach. So under the pre-reform common law approach, which we've seen before, we can put it all together now, there must be the intent to commit the specific crime, here, homicide, murder, and the overt act towards commission of a crime, and the failure to consummate a crime. And so the overt act was a effort to distinguish between preparation, right, and perpetration. And so there should have been a direct movement towards commission after the preparations have been made. All right. And that was narrowly interpreted and made liability difficult to attach. All right. So there was the initial statutory approach that made it difficult to find individuals guilty of attempt crimes. So the jurisdiction, the legislature modifies the statute, and it modified the Model Penal Code's approach, or it used a modified Model Penal Code approach. And so the state did not enact Model Penal Code section 5.01 subsection 2, which sets out those specific examples of substantial steps. Just offhandedly, the federal government and a small number of states did adopt this subsection, but it has not been widely followed. All right, so most jurisdictions who have adopted attempt statutes based on the Model Penal Code adopt the first portion, but not those specific examples of substantial step. And so the issue here is whether under the modified attempt statute, the defendant's conduct, the girl's conduct, constitutes a substantial step. And the court holds that when an actor possesses materials to be used in the commission of the crime, at or near the scene of the crime, and where possession of those materials can serve no lawful purpose of the actor under the circumstances, the jury may or is entitled to, but is not required to find the actor has taken a substantial step. All right. So here the court ultimately affirms the conviction and the girls are guilty of attempt, right? This is an incomplete attempt. So we're looking at A3 and B of the Tennessee statute. The conduct evidence is a substantial step towards completion, and the conduct is strongly corroborative of the actor's purpose. Is it a substantial step? Yes. They had the rat poison at school. There is no lawful reason to have rat poison at school if you're a student. They possess the rat poison near the coffee cup at the school. There's no lawful reason to have rat poison near your teacher's coffee cup at school. And so a jury could pretty easily find that they had completed a substantial step and that their conduct was strongly corroborative of their purpose. So as to the strongly corroborative, right, they were right near the coffee cup with the rat poison. And maybe the only reason they didn't actually go through it was because they got called to the principal's office. Now, it is possible to argue that their acts were not strongly corroborative of their purpose to commit the offense, right? They didn't take that last step. They didn't put the rat poison in the cup. And so maybe they didn't have a genuine intent to kill their teacher, right? These are young girls. They are seen giggling. They are apparently talking about running away to the Smoky Mountains. And so that could all be fantastical and juvenile. And maybe this was more like a game or a fantasy. And so this seems to be the point of the dissent. All right, but the government has a strong argument that they took a substantial step towards commission of the offense and that their conduct was strongly corroborative of their purpose to commit the offense. And so they are guilty. All right, we are almost done here. So let's give you an opportunity to work through this question of preparation versus perpetration on your own. So if you take a look at pages 782 to 783 in the reading, there is a fact pattern that is supposed to help you draw the line between preparation and perpetration. And you are given a number of different scenarios in the notes after that fact pattern. So on your own or with a partner, try and work through the fact pattern and the various notes to see when you would identify that the defendant has crossed the line from preparation into perpetration. And you should do so by considering the various tests that we've seen so far. So the dangerous proximity test, the physical proximity test, the unequivocality test, right? Or even the model penal code approach, right? Has the defendant crossed the line from preparation to perpetration? This is usually a fun exercise to do, notwithstanding the seriousness of this, because individuals can vary sometimes a little bit widely on when they think the defendant has actually completed the steps necessary for an attempt crime. So let's work through those on your own or with a partner, and then let's talk about it on twin and see if we get different results, or maybe we'll all come to a similar conclusion. So the last slide here is just a summary of attempt crimes, regardless of whether we're talking about the common law approach or the model penal code approach, right? This is the general, right, overview of what is required to prove attempt crimes. We have to have some sort of a substantial test for the substantial step for the actus reus. We have to have moved beyond mere preparation into perpetration. And then we have to have two mens reas proven. The mens rea, the intention to do the particular act that constitutes the crime, and then the intention to accomplish the crime. You have to intend the specific crime or the specific result. Okay, so that's our brief conversation about attempt crimes. And again, just a reminder, we won't talk more in depth about the other inchoate crimes. The video provides enough of an overview just to put them on your radar that beyond attempts, there are other inchoate offenses that you should be aware of. And so that concludes our discussion of inchoate crimes and attempt. If you have any questions, thoughts, or concerns, let's talk through them on twin.